Okay, we can get started here now. So what I'd like to do is I'd like to, introduce the, I'll briefly introduce everybody, but I will also ask for you guys to, what I've been doing is asking everyone to supplement the introduction with information that gives an idea of your background, even your technology background, or how you got into this, which might be useful to understand where you're coming from. But what I will do is I will introduce the panel, and we will start with Bob Spar, who is the Deputy Commissioner for Patent Examination Policy.
Did you just call me Bob Spar?
Oh my God. Okay, Bob Stoll knows why I did that, because I was just talking about Bob Spar, telling a story about Bob Spar. I'm sorry. We do not have Bob Spar here. We have Rob Barr. Bob Barr. Bob Barr is Deputy Commissioner for. Let's take two.
Yeah, here we go.
Okay. We have Bob Barr, who is, and I was looking right at you, Deputy Commissioner for Patent Examination Policy. And for those people who don't know, that is a role at the Patent Office that is historically very influential and important, and particularly for all of us, because that's the office through which all examination policy originates and is made. And Bob sends the memos out to examiners, which all of you complain about. I don't complain. I mean, Bob sometimes makes a pile of what smell like a bunch of roses. I don't know how he does it, but we're going to talk about how he's going to do that with Amgen here today. How do you explain Amgen to examiners? But we're really, really seriously very appreciative of you being here. Thanks, Bob. Then next we have. I will introduce Brad Peterson, and Brad is a partner now at Barnes and Thornburg. How long have you been here? It's a recent
6 months.
6 months. So Brad is new to Barnes and Thornburg, and we'll maybe hear a little bit about that. Next, I will introduce. We have Dan Evans, who is a partner at Merchant and Gold. Thank you for being here.
Gould. Yes.
Gould. Okay. Gould. I'm just doing really well.
Renee, did you find Gene's glasses? I think he needs them.
They're looking.
And I don't have them. Oh, you know what?
In your pocket. Of course they are.
Don't tell them. Let them keep looking. And last but not least is Tara Russell, and she is a senior manager and senior counsel for Capital One. We're lucky to have a couple Capital One folks here today, and I know the chief IP counsel there, and I invited him, and he was not available. He said, but I have two really great people, and Tara was one of the folks who was recommended me. So thank you all for being here on this panel. We really appreciate you being here. So now what I would like to do is back up again and start from the top and get each of you to give me your initial thoughts, and we can go in the order in which I introduced you. Bob, when you hear the topic patent robustness after Amgen, there's a lot in that title that we have, all of it really relating to 112. Where do you want people to kind of initially focus their attention as we begin this conversation?
Sure. Thanks, Gene. First, I'm Bob Barr. I'm a Deputy Commissioner for Patents. Really, for us, Amgen, or at least for me personally, was not a huge, I'll call it, change in the law. This was not like that quartet of 101 cases we got a decade ago where we said, stop the trains, suddenly new guidance came out, there was a shift. This more, to the extent that you don't like it, it's a nailing down of where the Federal Circuit was going. The Federal Circuit decision was affirmed. There was nothing really not nice about the Federal Circuit's decision from the Supreme Court. So if I were a Federal Circuit judge, I would be feeling pretty good after the decision. So what we did issue, and is now posted on our website, is we simply sent an email out to examiners that basically said what happened, that Amgen was decided. It was a unanimous decision. We said we're studying it, and we will see whether, what guidance is appropriate. But for now, stay calm and carry on, basically continue to follow the current guidance, because we felt that it's fully consistent with Amgen. The thing with Amgen, and I'll say 112 enablement in general, is unlike subject matter eligibility, that's very much a question of law, whereas written description and enablement are more, they're very fact-based decisions, so it's very hard to give any general rules to examiners. One thing I did notice is a couple of weeks ago, the Federal Circuit decision came out. It was from a PTO case. It's not precedental. It wouldn't be the case I would choose if I had a number of cases to choose from, but since I only have one, it was the case I looked at, where it was an enablement case. It came from the PTO, and the Federal Circuit, they cited to Amgen, they mentioned it, and then they went right in and said that the WANS factors informed the decision. So my sense is that the Federal Circuit doesn't see Amgen as changing where it is today.
Mm-hmm. Well, I guess that's okay. I mean,
Well, that's my answer, Gene.
So you did. That's your answer. So it is the right answer, as it turns out, right? And we'll talk about this a little bit more. But that's what I love about you. We get a decision that in 10 years from now we're going to look back and say, "Oh my God, the Supreme Court has wrought all kinds of terror," and the Patent Office, and Bob, you in particular, are like, nothing to see here. Just carry on. But Brad, your initial thoughts on Robustness 112. Feel free to take it wherever you like to go.
Sure. So Brad Peterson joined Barnes & Thornburg after 20 plus years at a mid-sized boutique in Minneapolis. Have been doing a lot of writing about American Invents Act, and Bob knows because I do a lot of commenting on all the proposed regulations, including this last robustness one. Kind of EE is my background, so definitely will be out of my realm of expertise when we come to the technology, and I think that points to Bob's question about how the fact dependency of enablement is really makes it much different than Section 101 issues that we've got to work with here. My thought on this one is kind of what can you do as a patent practitioner both in the biotech area and outside of the biotech area to make sure that your enablement allows your claims to live in that Goldilocks zone of really capturing the invention. Not too little, not too much. The challenge with this case, as I understand it, was trillions and trillions of possible combinations that could be claimed by the genus claim, and that was kind of concluded to be too much. And so are there some things that we can do there? And we're going to talk, I've raised some topics about that.
Okay, great. Thanks a lot, Brad. Next, we have Dan. Your initial thoughts on this.
Well, on the decision after listening to Bob and Brad, my guess is that the Supreme Court says, we're sorry for screwing up 101, so we're going to maintain everything in 112 enablement. Because there was nothing really that, there were a few select passages, but it was always answered this question, biotechnology is unique. And what the Supremes did in this decision said, no. You go back in time and back to the, telegraph and, the fibrous filament.
Celluloid.
It's the same, regardless. So don't panic. All is well. What'd you say, Bob? Continue
Keep calm
on.
and carry on.
Yes. Keep calm and carry on.
Yeah. Okay, so next, if we can, and last for the initial thoughts, Tara.
Yeah, so Tara Russell, Capital One Senior Counsel for Patents. My technological background happens to be in developmental genetics, so why I'm at Capital One is a bit of a long story, but for the sake of this discussion, I do have my share of experience with genus claims, so for whatever that's worth. And I think that from my perspective, the question immediately goes to resource management. Is this decision going to change the resources that we need to put towards any individual patent application? If so, what, why? And in order to inform our distribution of resources, meaning time and money, do our patent practitioners need more information from us? Do we need to pull more from inventors? Do we need to be looking for different things in our disclosures? So that's where my question goes. And I've had a few different chats with the rest of the panel here about this, but I'll save those for later. But that's where my mind goes first.
Okay, great. Well, thank you very much. So now I guess what we should do is we should go back and start with Bob again to go a little bit deeper into this. So I promised you that I wouldn't ask any difficult questions. Well, I didn't say that exactly. I said everybody has a job currently and everybody will have a job tomorrow based on my questions. So I'm not looking for anything to get you in trouble, but what can you tell us about what the Patent Office is thinking about with respect to the push for robustness and the push for a better, deeper specification and that sort of thing? What can you share with us?
Well, in this context, first of all, my statement of keep calm and carry on, that was instructions to examiners, not to practitioners. Here, I think the situation, and my background is mechanical engineering, so I can read these cases, I can look things up in a dictionary, but if you ask me a question that's one step beyond the case, I don't know the technology. But my sense here is that what bothered this Federal Circuit and the Supreme Court is that there were a number of species disclosed. There was a lot of description, but all of the species disclosed was in sort of like one area, whereas the genus was a much broader area. It's sort of like, you describe all of the restaurants down the street in one Loudoun, and you're claiming all of the restaurants in Northern Virginia. And they just felt that wasn't enough of a description. Not so much that more particularity was necessary for those species, but that you needed to have species across the genus at least. And so where I'm thinking is that, if you have to be somewhat careful about drafting genus claims, and that you have to make sure that your species are more across them and not just in one small locus in the middle. As far as the PTO is concerned for robustness, is that what we're looking for is basically trying to change our practices or change the background so that patents are more likely to stand up in court than they do today. And this is always a challenge because, the Amgen patent was examined back in 2013, 2014. We're applying 2023 law. Today's patents will be judged in 2030. But to the extent possible, you want to have specifications that are sufficiently robust that they will support the claims that are ultimately, issued and will stand up in court.
Yeah. That's the goal, and Brad, it's getting harder and harder to do that, right? Because you as a practitioner, as Bob sort of alluded to, so nothing to see here for examiners, but I think we know how this could really be interpreted, and if it's interpreted by courts who already maybe don't like patents that much, or believe they are monopolies, or are suspicious, then we have a problem, I think. So what do we do?
So what I would say from the practitioner's perspective is I always like to treat IP as insurance for profits. And when since I do mostly entrepreneurial clients, I've got new clients, I say I'm going to ask two questions, neither of which are about your technology. Tell me your gross profit margin that you expect for this product if you commercialize it, and tell me your total available market opportunity. If you answer those two questions, you can help me formulate what level of insurance is appropriate for this protection opportunity that you've got in front of you with this new invention. So when it comes to what are we going to do with those judges or those tribunals who are disposed not in favor of strong and broad patents, I think one of the things that's going to be really critical is to, at the onset, as some of the earlier panels talked about, identify what are these patents going to be used to protect. And in particular, I would encourage you to take a look at one question, which is the type of recovery you're going to seek. Are you going to try and protect against a theft of this IP or a trespass? If all you're doing is protecting against a theft, courts are generally more favorable for this because society doesn't like stealing. And so your story to tell to the jury and the judge is much simpler. If, however, with a broad genus claim, you are looking to protect against trespass, more work is going to be required. And as part of the process of doing that, identifying that theory of recovery of what you really want to use this IP for early on in the process will give you a head start into saying how are you going to manage those budgets for these cases.
Yeah, I think that's a great way to look at it, and we'll come back to this. So let's put a pin there for a minute. Dan, your thoughts on maybe what Brad said or what you are thinking about telling your clients about what needs to actually go into the applications.
Yeah, well, that's a great answer, Brad. You're looking at a much higher level than what I ever anticipated. In my view, what I think the Supreme Court's telling us, be careful when you incorporate function, especially in systems that are unpredictable, right? And in this instance where you have an antibody that has, a number of determinants that it's looking to feel and touch and actually interact with, Amgen only described almost, not quite, but just a little more than 50% of the determinants that interacted with the so-called binding elements of what they claim. And so it was almost about 50, 60% of that entire thing. And so it was an unpredictable thing. There was a function there. You go to the U.S. Patent Office written description manual where they actually have claims that say composition of matter blank, it's got blank, and it functions as blank. If you just took out the function, right, and just focused on the composition of matter, I mean, these fact patterns in the examiner, I think it was 2008, and then originally they came out in 99 or so. If you look at those examples and say, why am I adding function? Right, you need to disclose a function, but is it necessarily required? Because the composition of matter gives you the full bundle of rights so that you can then assert that and then do with it what you want. You get in areas where you're starting to add function in lieu of structure, you're going to have problems, I think.
Yeah, so we're going to come back to that because function, I think, is a big issue here. But Tara, what do you? I mean, because you're from a totally different background than Amgen. At Capital One, I don't assume you're dealing with antibodies and immunology and that sort of thing.
Not so much.
But what are you now thinking about with respect to requirements for your applications?
Well, I think that our minds do go to function, but before that, there's a sort of this is going to be obvious to folks sitting here, but I mean, there's a sort of basic requirement of enablement that needs to be met in a patent application. That, especially when it comes to parts of a claim or steps in a method that are meant to perform a function, it needs to be met. And when I look at a detailed description that's been drafted and there's a part of a figure, a numeral that's just described by one sentence, it immediately brings the question to mind, is this even meeting, the basic requirement of enablement? So there's that. And then on top of that, I do think that, with respect to newer technologies that depend on AI, that depend on having, a machine learning process complete, rather convoluted process, there comes a question to, okay, well, how many different ways can this go? How many different ways could it, should we have to describe? And do we run into a sort of, genus problem there? I don't know if we do or not, but, that's where my mind would go with respect to the technology that I'm currently in.
So you think the focus on, well, maybe for so many of the rest of us outside the biotech area, we've already been living in a world where there's been skepticism about large genus claims.
Right.
So maybe Bob, maybe you are right. Maybe there is nothing to see here. He looks shocked that I actually said that he might be right, but I think you're right a lot. I mean, whenever I've given you grief, it's not been because of something that you wrote or you said. It's something that the CAFC forced you to write.
No, I think this is more an evolution than a quick step here.
Mm-hmm.
I mean, if you think about this, this Amgen case actually has, I'll say, been around the block a few times. Its 2017 version actually resulted in two changes we had to make in written description guidance in the MPEP. And it basically, one of those was basically putting the last nail in the coffin of the newly characterized antigen test. So, I mean, the Federal Circuit has definitely been moving this way. It's just that when the more recent one, the 2021 decision came out from the Federal Circuit, there really wasn't any change in the law that goes into the MPEP. It was mostly that the significance of this case was mostly that a jury verdict was overturned in an area where it's highly a very fact-based issue. And that was what really stunned everyone. But for the USPTO in examination, that doesn't really matter that much whether things are questions of fact or questions of law at the examination level.
So what about what I was just mentioning with Tara about, the rest of the patent community has really been living in a world where there has been skepticism towards large genus claims. Would you agree with that? And two, what do you think that the bar or applicants should think about?
Well, this is easy to say. I'm going to say think about this. Doing it's much harder. You have to think when you're drafting an application, you're drafting it today. That thing's going to have a life of 20 years. You really don't know what the law is going to be like 20 years from now. You can't draft it with like last week's guidance in mind. You have to think about what could it possibly be in the future. I mean, 20 years ago, it was somewhat talk practice. Disclose very little, claim the world, and go for it. And that might have worked then, and there were probably applications drafted with that thinking in mind, where today I would want to make that, to use a phrase we all love, I would want to make my application or my disclosure as robust as possible so that, whatever the regime, it would have the best chance of standing up.
Yeah.
Obviously, doing that is a different thing.
Yeah. So Brad, I want to get back to what Dan was talking about with the functionality and so forth, because I know that, and we're going to turn these lights on here, so watch out your eyes. I turned them off during lunch so that we didn't burn them out. But so Dan was talking about functionality, and I'd like to get you to respond to what Dan said, because I know you think means plus function may be a way out of this, and you've thought that, I think, for a while. And I've always thought that attorneys use means plus function claiming way too infrequently. And the litigators I talk to say, where are the means plus function claims? Because they're uncertain, and cases settle at the edge of uncertainty.
And to me, this is one of those things. Tom Irving, everybody's heard Tom Irving because he's got a very loud voice, obviously. But if you listen to some of his guidance, some of it is, and go ahead and throw in a means plus function claim. It's never the sole source of your claim protection.
Right.
But going forward, in my mind, two elements of equivalence are going to help in all of the technology areas this issue of how do you get that robust enabled claim. One of them is means plus function, having some means plus function claims in there, and getting the equivalence of what you have disclosed by statute included. Now, the problem with that, of course, is those equivalents are limited under one of the Federal Circuit cases here to what is equivalent as of the date of issue, which is a really weird test when you think about it. It's not the date of invention. It's not the date of infringement. It's some kind of date in the middle here that you get the equivalence for. Separate story there in terms of what's going on. But the other thing that you will have an opportunity to think about as you prosecute the case is doctrine of equivalence. So neither means plus function nor doctrine of equivalence have been in vogue over the last 2 decades. 2 decades ago, biotech was pioneering. Broad genus claims were, much more common. We're now 2 decades in. And I think that getting to that penumbra of the right size scope of coverage is going to involve both literal infringement and taking us back to Graver tank and doctrine of equivalence. Because the doctrine of equivalence solves what I always say is the Dick Cheney problem. Okay? You're going to disclose the known knowns. You know these. You may forget to disclose some known unknowns or unknown knowns as what was equivalent at the time of the issuance, but you never know about the unknown unknowns, the after arising technology. And if you want your claim for one of these, trespass type of recovery strategies to be broad, you're going to want to leave open the doctrine of equivalence, which after Warner Jenkins and Festo means you can't be amending all that much.
Right.
So you got to know where you're going beforehand and really have a good plan on how to get there.
So what I'll say is when you brought up Dick Cheney, I thought you were going to use a shotgun analogy.
That's what I was waiting for.
Yeah. So Dan, I'll let you respond since you brought up functionality. I mean, agree with Brad, disagree with Brad? Where do you stand on means plus function claims?
I think if you're going to talk about Tom Irving, you need to add a little enthusiasm, right? I mean, I've seen so many presentations from him, and he's always saying means plus function.
Yeah.
And the reason, learning as a practitioner, a chemical practitioner, I was always told, stay away from means plus functions because the examiners don't know what to do with it. The chemical, the biotech, pharma examiners, they don't know how to handle it. And I actually introduced a means plus function, and I had a discussion with an examiner recently. She's like, that's pretty clever. And so kudos to Tom and all the times it finally sunk into this thick head. But, adds a little uncertainty, of course. But from what I was trained, don't touch means plus functions because you're going to be limited to what's kind of in the specification. And so it'll be the known knowns. So yes, fully enabled, but is it really valuable? I don't know. But that's the uncertainty, right? That's where the excitement kind of comes in.
That's where the value for the litigators come.
Right.
I mean, and I have been preaching this as well for many years. It's like, don't use only means plus function claims, but for God's sake, put in 1 or 2. And because I always tell people, how often have you been allowed to claim the full extent of the specification you drafted? And I only know one attorney in one case, and I'll tell you this, and if you go back, you'll be able to figure out what it is. He represented an internet company, and this owner of the CEO of the internet company, he would parade around bills from his patent attorney. I paid $250,000 to get this application filed. You want to come after me? You can come after me. And he one attorney, he filed like 5,000 claims in an application. It was PR. It was a PR stunt. But aside from that one case, I don't know any attorney ever who could say I was allowed to file all the claims and seek all the claims that I could get under my specification. So, and if you can't, then why not throw in 1 or 2 means claims? It's going to limit you to your spec. Well, you're not even claiming the full extent, usually, of the spec.
Include all statutory classes of subject matter. That's the golden rule when you're drafting a patent application. And I think we've overlooked means plus functions for way too long. Yeah,
I agree. And Tara, I saw you shaking your head. Now, yes, it seemed to be an agreement. Well, maybe you were in disagreement, but you were engaged in that back and forth we just had. So let me ask you, from your perspective, from a different area, certainly than Amgen, and an area that I think most practitioners have for a very long time been told not to use means plus function claims. What is your feeling?
Well, I think that it is, if you're talking about a belt and suspenders approach, it's a type of suspenders, isn't it? It's one of the options available to you. And, I'd want to know, given the particular case, if there's downsides to a means plus function claim, and I would be surprised if only means plus function claims showed up, but I wouldn't expect that. And so as an option, I would be interested in seeing it and analyzing it and making sure that it's, not detrimental to try it. But I don't see a downside to that approach. I mean, it does get into the resources question, which is always, I guess, where my mind goes next. But that kind of goes back to what Brad alluded to at the beginning. I mean, what is our case for? Brad mentioned, is this for trespass protection? Is this for theft protection? I'll push it even further. Is this going to be for enforcement at all? What is the purpose of this particular patent application that's being drafted? And so given the particular purpose, if you have the resources to throw a bunch of different types of claims at it, and it doesn't have to be 5,000, it can be 30 or 25. I absolutely think that it's an option to consider.
Yeah. So I think I heard your name mentioned there. Do you want to respond to anything Tara said? And I know Dan was talking to you and back and forth. So before we move on, I just want to throw it over to you.
No, this is definitely, it's an option, and it's one which you need to use judiciously based on what you're trying to do. And obviously, a going concern Fortune 500 company is not going to have the same objectives for cases in their patent portfolio, and they're going to evaluate them differently than a startup or an emerging tech company. And for startups and emerging techs, patents sometimes are not theft, trespass, or enforcement. It's raising money. Mm-hmm. And so you have a completely different purpose that really is out there for being able to do that. And so they may need to have broader claims because you're looking for showing more of a security blanket to your investors. And so the other thing that, in addition to doing the means plus function, when you get those cases that are valuable and want the kind of broad protection, you need to keep the children alive. And that's just, again, another one of those good prosecution techniques is always have a con pending.
Yeah.
But not too long, because we recently learned that if you let things delay for too long, you might get smacked around by the Federal Circuit.
Which is interesting, because if the Patent Office delays, it seems to be okay.
Yeah.
Well, you get benefit, right? You get your PTA.
Right. But once the Federal Circuit peels that particular layer of the onion and starts talking about delay and stuff like that, it does worry me about the whole thing, because how do you know who's really to blame for the delay? I mean, you get PTA if it's the Patent Office fault, but it's always struck me as odd. I mean, we get 6 months. The law says we have 6 months to respond. If you keep using what the law gives you, how could you at the end have done anything wrong? Fundamentally, I don't like when you have a situation where you have, in antitrust law, they say, oh, get bigger, get bigger, get bigger, encourage small companies to grow. And then you get so big, it's like, oh, okay, well, now you got to have handcuffs.
You're too successful.
You're
right?
too successful, right? And that's a problem. But Bob, let's go to you. I saw you smiling a couple times during that, and anybody who knows me knows that that's a mistake, because that means you're going to get called on.
Oh, shoot.
So what is the Patent Office thinking about 112? I mean, and I know it's a big question. I can focus it a little bit more, but if you want to share any of the current thinking, and the maybe the specific question that might get you going would be, over the last several years, many of us in the industry have noticed that there has been an increase in the amount of 112 rejections in office actions, and just don't know where that came from or why. And I don't know whether there's any there or whether it's just they're better computers and.
I don't know. I mean, there hasn't been a purposeful make more 112 rejections. I've been around the block a while, and I will tell you, before 2000, there weren't a lot of 112 rejections getting affirmed, that we were making, and so there was a tendency to not make them. But between like 2004 and 2010, more 112 rejections were being affirmed, and so there was more, I don't want to say emphasis placed on them, but more teaching that, hey, this is a condition of patentability. We should be also looking at it. Don't think that any 112 rejection you make is automatically going to be reversed. So, in appropriate cases, make them. And so that may have just been filtered out, and now it appears that there are more 112 rejections made because there were fewer earlier.
Mm-hmm. Okay. So what is the rest of the panel notice with respect to 112 rejections? Any changes that aside from them becoming more common than they want and longer and more detailed? Have you all experienced that?
Oh, wow.
Dan?
Yeah, every case is different. I will see with greater frequency 112 issues, but that's when I'm pushing the envelope, right? When I am trying to capture subject matter that I know is somewhere along the Romulan curtain, if you will, or if you want to use that type of expression, some sort of nebulous area where I don't know where anybody has gone before, but I want to go there, and in which case you'll see a 112. And that's understandable, and you expect and anticipate that. And so you have that thread of information that provides you with the rationale to get you through that. And I had a recent case like that. So you know it when you anticipate whether it's going to be a 112 or not, and then you get surprised when you get an indefiniteness along the way. So it happens, excuse me, and we just have to deal with it. And it is based on a case-by-case situation.
The one thing that I would say that I've seen on the 112s, because I still do use means plus function, so I tend to follow my advice sometimes, is that you'll see the examiners doing now in the guidance in the MPE, going through and identifying, since my cases are mechanical or electrical or computer med tech, the structure, and then saying we're going to limit you to this structure and the equivalence thereof. And so that part of the office actions will be something that you'll need to plan if you're going to go ahead and try and use means plus function claims, because you will expect to get those back, and you need to kind of figure out, okay, am I okay with that, with where the examiner is trying to draw that Romulan curtain or not, and kind of try and figure out if you're going to have to object to it.
Yeah. It's interesting. So, Bob, the examiners have not been told to do more of this, or
they've been encouraged to do is to indicate when the claims are in means plus function format, and Brad, there is an alternative. Is if you make clear what the corresponding structural material or acts are, sort of preempt the examiner, then you can avoid that problem.
Yeah, and then Tom would come and yell at me.
Oh, you have to. You can't let Tom scare you.
Yeah.
But no, examiners have been taught, obviously if you have a 112F element, there has to be corresponding structural material or acts, or it's a 112B problem now. Sorry, I'm old.
112 second. Go ahead and say
112
it.
second, yeah.
We knew what you were thinking.
So
you're among friends.
They're trained now to look for that, and obviously if you must have that. I'll say, going back to your earlier point about using 112F limitations more often, I'll say, obviously you have to have corresponding structures, whatnot, to get C or get a D minus. But the better work is to have different examples of them, so that when someone looks at what the range of equivalence is, it's a little broader than it is just if you have one.
Yeah, and it'll be interesting to see, because you also have the issue that's complicated if you've got a computer software or probably even AI disclosure now. What are the structure that you are required to disclose in that to satisfy the structure elements? There's a lot of uncertainty in that area.
So, and I don't mean this to sound condescending or anything to anyone, but there has always been the belief, and I think it's correct, that examiners just don't read the spec. And if you look at the amount of time that they're given to do a case, it's not intended to be a dig. But what I don't understand, so I keep trying to wrap my head around it, because I've been told by folks that there's no additional AI type assistants that are helping the examiners with the 112 rejections. But I'm pretty sure you haven't given the examiners more time. And I don't know it doesn't compute to me. It's like ships passing in the night, because when you talk to people, it's like I ask them, so if examiners started reading the specifications, and they just start laughing. It's like, well, how do they make all these 112? Is there any kind of computerized assistance that examiners can rely on that they maybe didn't have 10 years ago?
Well, I would say not. We're working on systems to help examiners identify the 112F and corresponding structures. So that's a work in progress. I think, and unfortunately, Drew would know better than me on this one, whether I believe examiners have gotten more time over the years, maybe not significantly more, but more time. But they've always been expected to read specifications.
Right.
Yes.
Well, and I think this is where the previous panel's comments about collaboration with the examiner can also, come in very handy, because if you're sitting on the same side of the table as the examiner and you say, look, this is what we were going for, this is what we meant, that's incredibly valuable. And if you can do it in an interview, and come to an agreement on what was meant, that's, one way to sort of. One thing that our outside counsel does that I really like is they'll file something and then they'll call the examiner and say, hey, we just filed this response and it addressed this, but if you want to talk through it, let me know. I had some things in mind, and if they're not clear, I'd like to discuss it with you.
Yeah.
Interview is too formal. Courtesy call, hey, heads up, I'm here to help.
And the other one is using that in a fast track case, because
yeah.
you get the courtesy call pre-first action on the merits, and especially if you've got something where you want to walk them through the parts of the spec that may be relevant to what you're talking about, I would definitely say, hey, think about fast track and think about that courtesy call before the first action on the merits.
So Bob, what happened to, there was a pilot program, I think, that wasn't just in the fast track where you could do a first action interview, and I thought that was just brilliant, for the reasons Brad was just saying. You could call the examiner, talk to the examiner. If you really wanted to play ball, you could say, look, these are the claims, this is where in the specification the claims can be found, relates to this, this, and this. And it just seemed like, the examiner would get an hour and you could spend bringing the examiner up to speed. It just streamlined everything. But I think that went away, didn't it?
Well, the pilot went away. And what basically the evolution of this is that under the rules, years ago, there was basically a prohibition against pre-first office action interviews. We amended the rule to take that prohibition out.
Right.
So we didn't need to do this as a pilot program anymore. If you want to have, if it works out that you can have a pre-first office action interview with the examiner, there's nothing that stops that. So there's no need to have a special program to do it.
Okay, so it's still available.
Yes. A pre-first office action interview is still available.
So is that, do examiners have discretion or to deny, or yeah.
Yes.
Yeah.
Sometimes you phone a friend, sometimes you get one.
So
Jumping
that jumping in from the background without even turning around, I can know that was Bob Stoll. And we have a microphone up here if you want to come and tell what you think or ask a question, Bob, or you too, Drew, if you're here. Yeah. I can hear you. They may not hear you on the recording, but and therein lies the problem, right? Is examiners can say no, and I've actually increasingly heard that examiners won't do interviews at all ever, and it's really pulling teeth to get examiners to do interviews. And I don't understand why that is. I mean, the cases get allowed quicker and easier more often. And why would examiners have, I don't know. Thoughts, anybody?
Oh, I wish I understood. I had one examiner where I was begging. What did John say earlier? Please give me a patent.
Right.
And the examiner just ignored me and just kept, willy-nilly doing what they wanted. And I just don't understand it.
Is this like the examiner refused to have an interview with you, or just
Never return call.
You
would file a request for an interview with your response. You would say, please, please, please. Nothing. And that's an exception, not the rule. For the most part, there are a lot of folks that have interviews and discussions, and we can work through it and sit in the same table and say, hey, let's get a patent here. Let's get something valuable for the client. There are a few. I wish I knew. All right, where's that crystal ball?
Have you used the ombudsman program in those situations?
Yeah, I've used the ombudsman program. Patent examiners are people. And when you start going around them and getting confrontational, my experience is that it comes back to bite you in the patoot. In which case, I'm not inclined to. I tread very carefully on that territory. So, yeah, I mean, you can do that. I've learned my lesson where you contact the examiner supervisor, what's going on here, and then the examiner doubles down and ultimately doesn't allow the case.
Yeah.
So, you know, you just got to be considerate and kind, and I don't know what else to say. Maybe where's the magic 8-ball?
Yeah, well, isn't that sort of why you need to hire people like Bob Stoll now? To like, you have a bad case at the patent office, the examiner won't do what you think they're supposed to do, and then you hire somebody who's got real experience. Bob's not the only person who does this.
We never listened to Bob Stoll.
Yeah, right. Well, you didn't listen to him when he was there either, but. This is beat up on Bob Day. We're doing a roast, but no. But the thing is there are people that specialize in these lost cases. That, you know, Todd used to do that. Todd Dickinson used to do
Mr. Wolf.
Yeah, yeah. When all things are going, see, I get that reference. How many people got the Mr. Wolf reference? You know,
Harvey Keitel,
call the
Fiction.
wolf. You know,
I'm the wolf.
Yeah, it's from Pulp Fiction. So, but Bob, let me ask you. So if you're not going to call the wolf, if you're not going to call one of the guys or gals, I think there's a few women that do this as well, that, you know, had real experience, like in your position, commissioner position. Todd was obviously director, who can cut through the maze. They know the people to call. They know the rules like the back of their hand. They know, and it's not like going over to the ombudsman, the examiner's head. It's a lot more cajoling. It's a lot more problem solving. If you don't have that, what should we do?
I mean, the path which you didn't really want to take is, you know, if an examiner is being unreasonable, you know, you should talk to the SPI. I really encourage you to do that. And if the SPI's not helping, you know, go to the group director. They do two things. First, they do want to help. Second, they want to know what's happening in their TCs. And if no one ever complains, people think that everything's just hunky-dory. So you're really doing a service by, you know, picking up the phone and calling someone. Now, unfortunately, interview's a bad situation here, because if you force an examiner to have an interview, I'm questioning the value of that interview.
Right.
And that's probably the one reason I would say, if I were thinking about it, I would probably not want to require that examiners have interviews, because that could just be, you know, having examiners just sit there and listen to you and say, thank you very much, file your amendment, we'll get back to you. You really have to have an examiner who wants to have the interview, or at least is willing to have the interview, or it's just not going to be productive as a practical matter.
Right. Or it becomes like court-ordered mediation. You know,
Right.
You're going through court-ordered marital mediation, even worse. You know, it's like nobody wants to be there. Everybody's got their own agenda. It's just so. All right. So let me look at the time. I got to put my glasses on to do that. It's pretty terrible. Okay, so we're probably down to the last 10 minutes or so. What is the takeaway message here about 112 and where we're going, and what folks should understand, and what people should be thinking about moving forward? Because real decisions need to be made. You know, kind of been making light a little bit about in Amgen, it's nothing to see here, and that sort of thing. But real decisions are needing to be made by clients as to what goes into applications. So I won't ask you this, Bob, because this is more of an advice question, legal advice question. But to the attorneys on the panel, Brad, let's start with you. What are you telling clients, and what should they be doing differently, if anything?
You know, the robustness of the disclosure is always an issue. The suggestion this morning of ask the inventors, can you fill out this a little bit more? I think that you're going to probably push on that more to get your inventors to help you out, and to even get the technology team that you're working with to help you out to make it robust.
So let me. What also came up this morning was and we're going to talk about this tomorrow with Will Covey about using AI. What are your thoughts on that?
I've thought about that one. Right now where we are is the challenges of confidentiality, attorney-client privilege, all of that other stuff right now. I don't know a lot of clients who would say, oh yeah, go ahead and use an AI to help me fill out the robustness of this specification and the disclosure of equivalence. But I can see a year from now, 3 years from now, maybe.
And let me throw this out because I would like to get you two to comment on this as well. One of the things that comes to mind, like when I was looking at ChatGPT, if you use ChatGPT through an API, then the information you give it, they say, based on terms and services, are not used in the corpus to teach it, other than to respond to you. If you do use it as over the internet as the open ChatGPT, then anything you tell it is going to get used and put into the corpus so it can give better answers to other people. What strikes me is, that we're constantly being asked to do more and more for less and less, and they want 1980s pricing, and we have 2023 spec requirements, and those are incongruous, So could you or should we be looking at AI solutions that are not open but closed, and not only closed but unique to your company kind of closed, like not on the internet, they're on an intranet? Tara, I see you smiling. I mean, is this something that Capital One has thought about, or you've thought about?
My fault for smiling.
Yeah, you shouldn't do that.
Let's see.
Bob is trying really hard right now not to smile. No, but seriously, what do you think about AI? I mean, and maybe the answer is you don't know yet. Has Capital One come out with a policy, for example?
Well, so I'll answer from my own personal non-Capital One perspective first, and that's just to say technology is always evolving, and AI is not going away, and ChatGPT is not going away. It's too useful of a tool. And so do we have to figure out how to operate within this world? Always, yes. Does that mean probably finding a way to leverage large language models? Probably yes. From the Capital One perspective, it's a whole business, and does the business as a whole need to feel comfortable with whatever risks arise with using tools, especially if we have to put our confidential information into those tools? It has to, do a whole analysis of that, and to my knowledge, we're undergoing that analysis right now. We're lucky to have a lot of technical experts in that field who work there, so that's helpful. And so I think that the world is naturally moving in that direction. But at the same time, I think that human creativity in the legal sphere isn't really going away. And so can ChatGPT or LLMs in general help us with language volume? Yes, but can they help us, take a whole business objective, figure out, based on that business objective, what kind of claim scope we want, based on that claim scope, figure out exactly what the bounds of the spec should be, so that we're giving what we want to the public domain, but, not necessarily something else that we don't want to give away just yet. I think that maybe is still a little bit far away, so.
Yeah. Okay, and Dan, your thoughts on that before we go into the lightning round wrap-up?
I'm not one to be discussing what AI can do for me. Right now, we're considering we're under a strict mandate to stay away from public AI, but we're now exploring private AI options, and I think it will provide us with an opportunity. But I think what Tara said earlier, she may have mentioned it directly or alluded to it. It was about the specification and providing the additional disclosure. And I think one of the takeaways from that decision, if you're deciding to claim sovereignty over an entire kingdom, make sure that you have that description that provides the quality that describes or instructs others how to make and use that class, if you will. So whether AI will get us there, whether it's a thick-headed noodle, we don't know. But that's all I have to say. It's very complicated, very exciting at the same time. And so,
okay. Thank you. Absolutely no. So we started a couple minutes late, so I'll just go until 2:20 on my watch here. So we have a couple minutes. So in lightning round fashion, if you could explain what it is that you hope people leave today remembering? Dan, let's start with you. What do you hope people leave today remembering? If there's only one thing, hopefully they'll remember more than one, but what's the key?
Oh, wow. Continue doing your due diligence and asking yourself the questions, and ask yourself, did I make a mistake? And that type of self-reflection will allow you to move forward, at least in the work, whether it be prosecuting, litigating, diligence. So use it as a roadmap, if you will, and ask yourself your own questions.
Great, thank you. Tara, your takeaway message for today.
I would say figure out why you are drafting or prosecuting the patent application and act accordingly. The last thing, like Bob said earlier, the patents that you are filing today, that we file today, are going to be subject to the laws of 10 years from now. And so the last thing you want is to have, the crown jewels of a client in hand and then to not have done everything that you could to make sure that you're protecting those against whatever changes in the law there could be in the future. But on the other hand, if you're just drafting, something to bulk up a volume of a portfolio, that's different. So understand the perspective from which you're drafting and the perspective of the client, and work according to that. It's not always going to work 100%. Sometimes, goals change over time. So, I always like to see a baseline description in there of whatever you're trying to claim. But that would be my takeaways. Understand what the point of the patent application is.
Great, thank you. Bob, your takeaway message.
Well, I'm going to steal a little from Brad. You just have to accept that if you have that case that you're going for trespass protection, you probably, and if you're claiming something at a genus or functional level, you want to have as varied species as possible. Numbers may not matter, but you want to have them across a scope so that whatever accused infringing product you have is maybe between them, or as like your species is not further from one of your species than the species are from each other. You really want to have that tool in your toolkit.
I like that. So you almost kind of chart it out and make sure there's not, like, you look at the distance between almost the points.
That's when I read the Federal Circuit's decision, I think that's what really bothered them, that everything seemed together, and then
Clustered.
the Sanofi example was far away from theirs.
Okay, very good. Thanks, Bob. Really appreciate it. And Brad, I'll give you the final word.
For those cases that merit it, because you're going for trespass, you're going for functional claiming, you're going for equivalence that may not yet be known, understand that that's going to take more effort. You're going to have to be more robust in your disclosure. And don't forget about doctrine of equivalence and means plus function.
Great. Well, thank you very much. I really appreciate it. Excellent conversation.